internal appeal mechanisms. For example, whatever they have cited on the issue of the NGO, it was a non-issue. Just allow me to address it. On the issue of the NGO, the refusal of the NGO board to register this NGO, this was an issue whereby he refused to reserve the name which was proposed by this NGO. And the refusal to reserve a name does not have internal appeal mechanisms. It is the registration which has internal appeal mechanisms. Therefore, the doctrine of exhaustion cannot suffice in this case because it is only the registration which has an.
What about on the issue of expulsion?
The issue of expulsion. The issue of expulsion, the doctrine of exhaustion cannot still apply in that case. Simply because these people were not even given that right to even be heard. So, this Vice Chancellor in this fact sheet, in the factual matrix, actually goes ahead to expedite whatever report he has been given. And she does not give them the right to be heard. And therefore, it is only upon the High Court to review or to subject the petitioners to the doctrine of exhaustion, whereby we have not exhausted those mechanisms. But we don't have the chance to exhaust those mechanisms because the Vice Chancellor has refused to listen to us based on chasing us away and expelling us.
What about the minister?
The minister for...
There was, I think in the factual matrix, if I'm not wrong, there was something that you're supposed to appeal to the minister. Was it not?
Yeah, whatever you have to appeal to the minister, I've just addressed it on the issue of the NGO.
Yes.
The issue of the NGO, there's an issue of registration and reservation. Okay. Whatever is provided for under the appeal mechanisms is registration and not reservation.
Yeah. I guess. Yeah. Okay. So, there's anything you want to say, Ibrahim?
I think he'll invite Ibrahim.
Okay. Your Honor, appearing for the plaintiff again, Counsel Ibrahim Oro. I'd like to address the issue on morality as they have propounded it. Professor Makau Mutua wrote in the Sunday Nation that the Constitution of Kenya is emancipatory and it stipulates and condenses all the rights and fundamental freedoms into one document. The courts should not inject their own moral predilections into the Constitution, but follow the Constitution as it is. This was also the position expounded in the case of Patrick Reyes versus the Queen.
Okay, the Constitution as it is says that sex is between people of different gender.
Exactly.
Yes. So why are you bringing this issue of homosexuality? Are you not injecting your own predilections into the Constitution?
I was injecting my own predilection into the Constitution.
And then you're telling the court not to do the same?
Not my moral predilection.
Yes.
But my learned research predilection.
Yes. Ours is not researched.
It is researched. Okay. But I was trying.
Okay. And let me ask you this.
Yes.
During Bomas, if the drafters of the Constitution wanted to have homosexuality as a right, that issue came up and actually it was shot down. And that's why in our Constitution is very specific that it says sex is between people of different, a marriage is between union. A marriage union is between people of different sex. So is it not by implication that they wanted to leave out homosexuality and the rest?
The implication was?
Yes. Why were they specific? Because they just didn't leave it. They were very specific.
The specifics was they were looking at the culture of the country.
Yes, and why do you want to move away from that culture now?
We are moving away from the culture because law is stipulated to serve the society as now. Yes. Law is not regressive.
Yes.
Law is prospective.
Yes.
And this prospective world has come to accept, even Christian churches are accepting homosexuality. Recently the Pope said that homosexuals are allowed in the church. The society is progressing. It is becoming a prospective thing in society. That's why we should allow the Constitution to serve us right now.
And should it be done through this court, which is a counter-majoritarian institution, or should it be done through parliament, or referendum, or constitutional change?
The High Court has struck constitutional provisions which were unconstitutional, and the court is given this power according to Article 23(3) of the Constitution.
Sorry?
The court...
Just a minute.
Yes.
The High Court
has struck out some provisions which were unconstitutional before.
Okay.
And I have the case.
Now it's better.
Yes. Because you're given that power under Article 23.3 of the Kenyan Constitution to strike out anything which is unconstitutional. Especially you can refer to the case of God versus Republic, where they struck out several security amendment acts, and even in the case of the AIDS Control versus the Republic, where Section 24 of the AIDS Control Act was struck out.
But that is outside now the issue what you are presenting.
Yeah.
So those provisions that are unconstitutional, it does not mean that because those ones have been found to be unconstitutional, then any other provision which is within our law, and probably it's not tallying with the opinion, and I'm using the word opinion in quotation, of some individuals, then it means it should be struck out as well.
The justifiability for striking out any constitutional, any legal provision in Kenya was propounded in the case of Kituo cha Sheria and 7 others versus the Attorney General, where it was said that to strike out any constitutional provision, you must first ensure that that provision is infringing on the right to dignity. And the right to dignity is provided in Article 1 of the Universal Declaration of Human Rights, and even Article 4 of the SCHPR, the African Commission of Human and People's Rights. And this is the same position which was held according to Article 17 of the ICCPR in the case of Tunnel versus Australia, where it was propounded.
Ibrahim, before you go further, you said something strange. That for you to strike down a law, it has to first infringe on the right to dignity.
Dignity.
No, that's not correct.
It was held in the case of Kituo cha Sheria and
So
It was specific
so that's
yes.
case,
Oh,
not
so
in all cases.
all laws have to infringe the right to dignity.
I stand getting with the court.
So thank you.
Okay.
Yes. Now we will retire and then do our collation rather than decide the people will be going to Embu, and then those people are putting us under a lot of pressure. They want the memorials by today, in fact. But I think by tomorrow, the group that will be chosen, or rather the individuals who will be chosen, they will have to burn the midnight oil and make sure by tomorrow the memorials are ready, right? So that you can send the memorials by tomorrow. Some of the things that I think we should consider in the memorials as whoever is chosen, right? So the first issue